Morning. No mention? Yes, call the list.
For information, supplementary list item number 13 to 16.
May it please your lordship. Lordship, my senior is currently engaged before some other court, your lordship. Lordship, may I kindly pray this matter come up after vacation, your lordship?
All right. This is item number
13 to 16, your lordship.
13 to 16. As prayed for by Mr. T. Kashyap, learned counsel, appearing for the respondent on the ground that Mr. K. N. Chaudhary has learned senior counsel leading the brief is having some personal difficulty today. Relist the matter for further hearing on such and such date. Yes, when do you want it, Mr. Kashyap?
Lordship, Lordship, in the month of October.
I trust you have already informed the other sides.
Lordship, no, as of now, we did not get a chance to acquaint with.
All right, but this matter is called, you're not mentioning.
No, Lordship.
Huh.
Lordship,
So,
may it be called on the
so and so.
7th.
And our report, anyone for the respondent is present?
13 to
13 to 16.
Cotton University.
Nam or none appears for the respondents on call. Yes. Give a date, Kashyap.
7.
Next.
Item number 1.
Just informed by the party, both the councils,
Hmm?
that they are in traffic. So
Okay.
can you take in the matter after some time?
All right.
Item 3.
I read a part heard Dasila. That is in the hearing. Oh, acha.
Well, this matter relates to acquisition of land for the purpose of construction of IIT Guwahati. Now, what happened, my lord? The LA award was to the tune of 10 crore, which was paid by Ministry of Education, and that was disbursed to the claimants. Thereafter, the claimants went for a referral. Then referral court enhanced the amount. Against that enhanced amount, the claimants, when the payments were not received, they went for execution. The executing court passed an award for attachment of the property of the office of the district commissioner of Kamrul. Thereafter, we came. The state of Assam preferred this writ petition. During the pendency of the writ petition, this honorable court on the last occasion directed.
The last part of Melon.
Yes.
Okay.
Mr. Day, right? Yes. What do you want to show, Mr. Day?
My lord, there was a direction on the on state government and central government to file an affidavit with regard to a meeting which was supposed to happen between the joint secretary and chief secretary. My lord.
Right.
To my understanding,
Yes, Mr. Day.
my lord, to my understanding, the central government has filed an affidavit. My lord, I was given a copy. Central government. I am for the IIT, my lord, for the respondent number 7. You have an extra copy for you.
Yes. What is the stand of the central government?
My lord, to put it briefly, my lord, they have looked into the matter. There was a discussion, my lord. And after the discussion, it was decided that they will request some few documents from the state government to further consider the matter.
When is this affidavit filed? You've received a copy of the
Yesterday.
central government?
Yesterday.
Yesterday. I don't think it is on record.
My lord, may I produce my copy, my lord? My lord.
Though in that case, I will post it on another date because the central government affidavit says that. Anyway, just give me your affidavit, Mr. Day. Correct.
They will require some more.
So in that view, we will post it after the vacation and we will direct the respondents to place the up-to-date status by that date.
My lord.
Correct?
Yes.
Heard Mr. A. Bhattacharya, learned counsel appearing for the petitioners.
Yes.
Also heard Mr.
AB
A.B. Day, learned counsel appearing for the respondent number
7.
7. Miss M.S.
M. Burman on behalf of Mrs. A. Gayan, respondent.
M.
number
Burman on behalf of Miss M.S. A. Gayan, respondent 6.
1 to 3. Respondent number 1 to
Mr.
SD Gupta.
S.D.
Gupta.
Forecaster for respondent number
1,
1, 2, 3 and
data for 4 and 5.
P. Deca, na?
A day.
A. Deca. So central government is who? Who's filed this affidavit? Burman, you have filed, right? It appears that the pursuant to the direction of this court, on 12/8/2025. MSM Burman, Learned Central Government Council submits.
Lordship, on behalf of Mrs.
All right. Everywhere in the order, I cannot be saying on behalf, on behalf. Then why are you appearing? So-and-so submits that an affidavit has been filed on behalf of the state government yesterday
Yesterday, my lord.
on such and such date, a copy of which has also been furnished to Mr. A. Bhattacharjee, Learned Counsel, for the petitioner. Stop. However, the said affidavit is not on record. Mr. Bhattacharjee submits that a perusal of the affidavit indicates that the process is still undergoing. In view of the same, let this matter be posted on such and such date, by which date the respondents shall place the up-to-date status of the ongoing process. List on such and such date, let registry verify and place the aforesaid affidavit in opposition stated to have been filed on such and such date on behalf of respondent number 6 on record.
Can it be on?
All right, you take this back, Mr. Day. This is yours.
Yes, my lord.
There are two petitions, correct? All right, in one petition, I'm an Eketa auditor, Mr. Bhattacharjee, you are in item number 2 and Mr. KM Hassan in item 3. Okay.
My lord, just one small thing, my lord. Direction of the last order was also on the state government to file an affidavit.
We will also file.
May also apply.
It is, however, whose state appearing for the state? Oh, this petition is filed by the.
State of Assam.
However, it appears that the state of Assam, i.e. petitioner in WPC 92 of 2023, has not yet filed the affidavit as directed earlier by this court on such and such date. It is needless to be clarified that by the next date of listing, the said affidavit shall also be filed.
My lord.
Eto buji palam na? Hey, order to.
Item 4.
One. Make please, lord.
Yes, Mr. Kaushik.
Whereas the matter relates to non-payment of 2 pending bills, my lord, under the GMC, my lord, pursuant to a work order, my lord, where we were entrusted with the work of segregation of legacy waste by the Trommels, my lord. And after the execution of the work, my lord, every time as per the tender clauses, my lord, we have submitted the bills and the verification is done by the authorities and verified that this is the work that is completed. Finally, the completion certificate has also been issued. And thereafter, my lord, the 2 bills are still pending, my lord. That is page 61 and 62 are the 2 bills. The final completion certificate that my lord will find page 64.
Who is appearing for the other side?
I have filed my affidavit, my lord.
Mr. Bora.
Proceed.
Yes.
First stand is, my lord,
Hmm?
to verify whether the work has been done or not. My lord, notification, a committee has been constituted. Lord, you will find page number 84 of my affidavit, my lord.
Page 54.
84, my lord.
84.
Running page number 84 and
Just 1 second. The prayer is at page 15.
Prayer, then
16 and
16.
16, correct.
To clear-
Release amount of so and so against the
2
two
invoices.
invoices. This work was for
This work was for segregation of legacy waste, my lord.
segregation of
Legacy waste.
Of?
Use legacy waste.
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 in the dumping ground, my lord.
Dumping ground. Using the trommels.
What does the word legacy mean?
My lord, in the dumping ground, you go on dumping, my lord. After a certain point of time, that dumping stops, my lord. That the waste have to be
Segregated.
segregated.
So the amount in question is 1,76,9. Oh no,
One
crore, right? 76
76
lakhs
lakhs 98,000.
98,731. And this, according to you, is pending since 22,
20.
right?
Yes.
Yes. Now let's see the stand of the government.
Lord, you will find those bills in page number 61 and 62.
Yes,
And my affidavit, my lord.
yeah.
In page number 84, a committee was constituted, my lord, to find out the whether the process has been completed as per the clauses, my lord. Ultimately, ultimately it was rejected, my lord.
This is done in 24.
This is done in 24,
After the repetition, my lord.
because certain other facts was there, my lord. Initially, the engineer who was there, he had who was to look after
This
that.
was rejected.
This was rejected, my lord.
Lordship will be surprised to see what they have asked for.
One second,
No,
Mr.
I'm
Kaushik.
sorry. I'm sorry.
Take your seat. I'm just trying to understand.
I'm-
I'll certainly come to you
Yeah,
when it is required.
Well.
Have patience.
I'm sorry.
Mr. Bora, where is it saying why it has been rejected in page 84?
My lord, the
It says only the committee shall examine. This is only a committee.
the following points were recommended as minutes, my lord. Page number 86. There is
Okay,
a minute.
okay, okay. That's what I was trying to locate.
Next page.
Yes. Yes, I've got the minutes. The
Ultimately,
claimant noticed. This is the petitioner. So it has been rejected on one ground that the claimant failed to produce the electronic weight bridge slips or other pertinent documentary evidence to verify the work done.
basically clause number 3, my lord.
Clause number
3
3 of the
of this minute, my lord, page 86.
that I have seen, but now is there any criteria for giving all this by the claimant? The electronic weight bridge slips and all? Because it has been, you see, there is no, what the authorities are saying is that they are not denying that the petitioner has not done the work. What they are saying is that the petitioner has failed to produce the electronic weight bridge slips. Correct?
Yes, ma'am.
Or other pertinent documentary evidence to verify the work done. Now, who is going to verify the work? Petitioner will verify. Who will verify the work?
As per clause 2, they have produced only
You see, Mr. Bora, I'm asking a simple question.
Lordship.
The work has been given to the petitioner. Now, who has to verify? Who has to certify that the work is done to their full satisfaction? Who has to do that?
Further, and as per the tender, my lord, page number 24, my lord.
Page number?
24.
24.
Scope of work, my lord. Here, scope of work, page 24.
Yes.
In that mark, my lord, down
Yes.
below, as the
Measuring.
measuring parameters will be on weight basis, the computerization weight bridge with CCTV facilities shall have to be installed in the suitable location for weight incoming legacy waste. Alternately, the selected bidder shall have to arrange third-party weight bridge for measurement of weight. The third party, the petitioner have to arrange the third-party weight bridge for measuring the waste.
But this is not done, Mr. Kaushik.
No, it is done.
Why you have not given those bills?
My lord will kindly see now. My lord,
I'll come back to you, Bora. You now take your seat. Let's hear the petitioner.
no, my lord,
I'm taking up for final disposal. I'm
Yes.
making an attempt.
yes,
Yes.
my lord will kindly see please 24, my lord, the scope of work, my lord.
Hmm.
From top, my lord, fourth bullet point.
Yes.
Monitoring of the weight bridge will be done by the GMC. What is required by us is, my lord, to install the weight bridge and to install the CCTV, my lord. Now, my lord will kindly see.
1 second.
And
To
the,
install the wave bridge
and the CCTV.
and the CCTV.
And
Right.
the monitoring will be done by the GMC. Now,
Right.
my lord will kindly see now. page 37 is the contract.
Yes.
In the second paragraph, my lord will see the amount of work that is to be completed is 3,61,000 metric ton, my lord.
I'm not getting that.
My lord, second, whereas, my lord, in the first whereas,
Yes.
whereas the GMC has selected the bidder.
Yes, yes,
through
to
the-
segregate 361,000 empty. This
And-
is the work.
Yes, that is the work. And my lord,
Yes.
again, page 39 contains the same scope of work that was in the ITB. The third and the fourth bullet point. Running goods will be still should be minimum 30% of the contract value. Monitoring of weighbridge will be done by GMC. And thereafter, my lord, lordship will skip two more bullet and the next one. Computerized weighbridge with the CCTV.
As the measuring parameter.
As the measuring.
Yes.
Now, my lord, to kindly turn to page 40, my lord.
Page.
Page 40.
Yes.
After the CCTV is installed as per the below the requirement of the contract, we have informed to the JMC authorities by on 10/2/2021,
Yes.
and the password and the user ID has also been given to the JMC so that they
Yes.
can monitor.
Yes.
Now, my lord will kindly see the next page 41.
Yes. Weighbridge.
Weighbridge. May I just read this?
Yes.
One weighbridge at Boragao dump site of GMC is in working condition, and we are using the GMC weighbridge for weighing the legacy waste as per the above tender. There is one weighbridge which is not working. We have done survey of this weighbridge which will cost about 2,50,000 to bring it to the functioning condition. That is the petitioner will use its own fund to get it repaired and use the purpose of weighing legacy waste. On completion of the process, we will hand over the weighbridge in working condition to GMC, which can be utilized by GMC. So, my lord, there's a requirement if we don't install, my lord, we can also hire it from the third party. Now, this means, my lord, the GMC's weighbridge, which was lying non-functioning, my lord, it was used by them. It was again handed over to the GMC. So we are not asking for refund of this money. So this means, my lord, we have successfully installed the weighbridge, and thereafter, my lord, will kindly see the process of monitoring by the GMC is apparent after every bills are submitted. Page 42.
Yes.
Page 43 are two bills for a period, my lord. Now, page 44, my lord, will see the type copy of the page 45.
Page 42.
42 and 43 are bills, my lord. I'm trying to show that after the bills are
These are bills that you have given.
yes, after the bills are submitted,
Hmm.
page 44 are the verification report by the authorities, my lord.
This is issued by
This is issued by the executive engineer, my lord.
Chief Executive Engineer.
Chief executive. Two authorities, my lord, one superintending and chief executive. Both were the authorities who monitors, my lord. All weight are being measured in presence of them,
Hmm.
and after that, my lord, they verify, and they have verified till that day what are the waste already segregated.
Are they denying this?
There's no denial to this. Look, it continued like this for after every bill. I won't bother your lordship with every verification report.
Hmm.
Finally, your lordship will see page 55.
But why these seals are not appearing in these bills?
Because of photocopy power.
Hmm?
all these documents were given to us in RTI.
But none of, they are not denied,
No,
right?
they have not denied.
In their affidavits.
Lord. For that, Lordship will to go to
Mr. Bora,
Lordship.
I'm hearing the matter.
Page 55
Yes.
is again one certificate, my lord, where the superintending engineer, my lord, has verified till 17th of April 2021. And after this, based on this verification, my lord, bills were paid. There were 11 bills, my lord, 9 bills were paid
Out of 11.
out of 11. Similarly, it went like this, my lord.
Yes.
Thereafter, the pending bills, my lord.
Yes.
In fact, before the pending bills, page 61 is the pending bills, page 60, my lord, will kindly see. Till this, there was no dispute.
Yes.
28 to 2022. It was an acknowledgement of till February 1 to 2022.
Now just tell me from which period to which period you got your bills?
From January 2021.
Huh?
January 2021. January 2021 till February 2022.
Yes.
The period which is due is 1st of March 2022 to 31st March 2022.
31st March.
Yes. 1st of March 2022, 31st March 2022.
All right.
1st of April 2022 to 20th of April 2022.
1st April 2022 to
20th April 20.
this is due.
This is. And after these bills were submitted, my lord, your lordship will see
And these two are at page 60.
60 and 60, 61
No,
and 62.
61 and 62.
61, 62.
Mr. Chaudhary, which matter are you waiting for? Yes.
Page 63, my lord, will kindly see.
Yes.
This concerns, my lord, the March bill, my lord.
Yes. Verified.
Physical progress of the work is 93% approximately. The performance and the work progress is satisfactory.
Yes. So this covers your bill 61.
61.
Yes.
Page 64, my lord, will kindly.
Yes.
This is the final certificate, my lord, acknowledging the completion of the entire 3,61,000 metric tons. And they have also acknowledged that the performance is commendable and work completed satisfactorily.
Yes.
Thereafter, my lord, page 65, my lord, will kindly see.
Yes.
They have asked me to remove my machines that were lying in the side, saying that it is after the completion I have not removed, and therefore they have asked me to remove the machines also.
Yes.
This is of 14/9/2020.
For machines removal.
My lord. So, my lord, what they have asked for, the wave bridge slips and the CCTV footage was never a requirement under the contract.
In
Because-
fact, it was the obligation under the contract of the GMC to monitor
Monitor.
the
And in my
performance.
yes, in my reply, my lord, I have categorically stated that the authorities, my lord, after doing it manually, used to maintain a logbook, and based on that logbook, this verification certificates are being issued.
Where?
Paragraph 7.
At 90, page 90.
9.
Yes.
That the purported justification projected in para 10 of the counter affidavit is baseless, unreasonable, and not tenable in the eye of law.
This
Most of-
14922 is page 65, that final completion,
My lord.
correct?
My-
Yes.
Further, the respondent authorities in their affidavit did not dispute and denied the letter dated 14/9/2022, which is again an acknowledgement of completion of work in addition to the certificate dated 19/4/2022 and 7/6/2022. Thus, under such circumstances, the constitution of a committee so as to examine the claim of the petitioner was not at all called for. Be that as it may, there was no such requirement in the work order or the tender regarding retaining of weighbridge and the CCTV footage, and therefore, in practice, the legacy waste after segregation was used to be weighed in a digital weighing machine, and thereafter manually it was recorded in the logbook maintained and monitored by the supervisor of the GMC, and the same used to be verified and acknowledged by the respondent number 8. Similarly, as contended above, the access of viewing and monitoring through CCTV was already provided to the authorities after its installation on 10/2/2021. There was no requirement of retaining the CCTV footage, as installation of CCTV was obligation of the petitioner, not retaining the records of this footage of the CCTV. The above purported examination of the committee is designed with a preconceived mind so as to deprive the petitioner from getting its due. Be that as it may, the petitioner, by this letter dated 12/6/2023, already submitted the mentioned document, which is enough proof of completion of the work. The finding of the committee in rejecting the claim of the petitioner for payment of 2 pending bills are arbitrary, unreasonable, and not sustainable. The petitioner duly executed and completed the work to the satisfaction of the authority, and to that effect, the authorities have duly acknowledged it by certifying the completion with the satisfaction, which has not been disputed or denied by the respondent in its counter affidavit. And thus now the committee's purported examination in respect of completion of the work by insisting upon the petitioner to produce electronic weighbridge slip and other documentary evidence for proving quantification and the standard of work is expressly illegal on the face of it, and it is an afterthought with a malafide intention.
Yes.
My lord, will kindly see page 96 of the
Reply.
reply mail.
Yes.
Pursuant to the committee's query, my lord,
Yes.
I have submitted all these documents for their perusal, and there's no mention about examining this document. This 12/6/2023,
Place this document. Read
my
it.
lord, Lordship will find in the 4th paragraph are the documents. Work order, extension order, page number 1, 2, agreement, technical sanction letter, pending invoice copies, duly signed logbook has been submitted with the inspection comment of JTO GMC. Copy of the sheet attached, photographs taken during the work progress, photographs taken during the officer visit to the site, executive engineer completion certificate, executive engineer letter directing a need to remove the trommels as work has been completed, logbook of the RDF loading by GMC supervisor. Commissioner GMC have given permission to Dalmia Cement for taking the RDF to their plant for disposal, and were sent to Dalmia Cement on so and so, so and so. Completion certificate in all respect by this chief engineer in the APWD format. So these documents are already there, which
This was given when? After that
when the committee has asked us-
rejected.
No, when the committee has asked us to submit the document.
And after that, the committee said it is,
It is, yes.
which is that letter again, that 84, right? 84 is constitution, then 86.
Madam.
Committee referred to the relevant contract provision, particularly those moving The committee noted that the claimant failed to produce the electronic weight bridge slips or other pertinent documentary evidence to verify the work done. And so now the matter rests here.
Yeah.
7924 minute.
Very well.
That is why it is now not being released, right? Okay. Anything else?
That's
Yes, Mr. Bora.
Why, my lord, first of all, why the matter was raised, so the committee had to be formed, my lord. What will come to page number, my paragraph number 8, my page now 76. Because the two invoices doesn't have the absence of the signature of the executive engineer division 6,
Page 76.
76, no, paragraph 8. The concerned division is division 6.
One
Executive-
second. One second.
76, paragraph 8, my lord. These two bills, right?
Yes.
Cannot process because there is an absence of signature of the executive engineer. And in the meantime, my lord, the executive was also arrested by the CM Vigilance for misappropriation of public money. Right?
Yes.
So in thereafter, my lord, that particular file also went missing. My lord. So the committee has to be formed, my lord. The 10-member committee. Ultimately, the 10-member committee took everything into its all the documents, and thereafter this minute, the committee has given this prepared this minute after going everything.
See, you may be right, because even this court have noticed that in those initial bills, few bills, I didn't see any signatures. Sorry, the seals. There was no seal. Generally, the seal has to be there. If you are verifying and you're signing in an official capacity, correct? Now, there could be such a situation, this court doesn't know. But what is now seen is that the committee finally rejects the claim of the petition on two grounds. One, that this particular weighbridge slips is not given. And number two, that some verification documents not there. But it seems that they have given the verification document. Now you see, Mr. Bora, you listen out. Because it appears that later on, a proper final verification is also done, which is at page 65. That's a final verification with seal and everything, right? For the total amount, for the total quantity of the work.
No.
It is clearly mentioned. So what I am saying is that you see, it's difficult because this court in writ jurisdiction cannot go into disputed questions. But nonetheless, if the petitioner has completed his work, he is entitled to the legitimate dues, right? All that the committee is required to do is verify properly. The document which you are showing does not inspire the confidence of this court that a proper verification has been done by this committee. They have mechanically rejected on two grounds. They have not referred to those documents which are at page 92,
96.
96.
90.
Nothing is mentioned. And that apart, it seems all these the CCTV, the bridge, they have hired. Now, who is going to monitor? Monitoring part is GMC's. Who is GMC? That is you. Now, while monitoring, if there was any shortcomings, you could have brought it to the notice of the petitioner. You see, I am only broadly saying, I don't know what has happened. It is difficult for this court to today dispose it of this way or that way. Perhaps one middle way could be that we may direct it to the committee to reconsider everything in terms of the
96.
huh.
Page 96, everything has to be there.
That can be one way if you both agree. Otherwise, it is difficult because it seems something has not been taken into account. You see, Mr. Bora.
Every document in the page 96, there are some documents have been given. That
So we don't know.
Right.
You see, because that para 3 of the minutes is very general.
yeah, that
It is very general. It is not inspiring the confidence of the court. Vis-a-vis the final confirmation and verification of the chief engineer at page 65, right? Let's come to 65.
65 is to remove, my lord, that is
Huh?
to remove the.
Let's see 65 once.
65 is the removal of the machinery. indicating
No, there's another one, no, that
That is-
final
64. 64.
60,
64.
64, yes. This is of the executive engineer. It says it is certified that so-and-so was awarded the work so-and-so by so-and-so and executed 361,011.75 metric tons out of total ordered quantity,
That
3
is-
so-and-so metric tons. The performance is commendable and work completed satisfactorily.
that is
Now,
the-
this is the total work,
almost the total.
almost total work.
You-
And this is given by your authority,
not see that. I have seen, madam.
isn't it?
Not see that.
Now, if you see this with the minutes, it says produce the electronic weight bridge slips. They have already installed the weight bridge. Who is to monitor? It is the GMC. The first ground is not inspiring at all.
No.
And the second ground, or other pertinent documentary evidence to verify the work done. What are these documentary evidence he has to give? He's already given it at page 96. What more?
Page 96 has not been taken. I don't think.
It has not been taken into account. It doesn't appear. So on this ground, I can interfere and resend it to the committee to verify properly.
Taking into that letter, but dated 12/6/2023. That is page 96.
Mr. Kaushik,
Correct. Was that?
agreeable to that?
Yes.
All right.
And also the final completion certificate.
Yes, that I'll mention in the heard Mr. B. Kaushik, learned counsel appearing for the petitioner. Also heard Mr. S. Bora, learned steering counsel GMC for all respondents
All this.
for the steering counsel GMC or within bracket respondent number is 1 to 8 Koyediba. By way of this petition under Article 2 to 6 of the Constitution of India, the petitioner is assailing, is canvassing his grievance against non-release of rupees 1,76,98,731 against 2 invoices dated 18/4/22 and 18/5/2022 in connection with RFP for segregation of legacy waste using, what is this? Teramels, trommels, others.
And other allied infrastructure and manpower.
It would be page 64, a good quote to a power. Put it in that quote only. Wide work order number, that is Paijava. Dated 22/12/2020. This is the work order, no? A to Koidiba, huh? This whole thing. The brief facts of the case is that where is that figure, that quantity, Mr. Kaushik, you had shown me?
My lord, the
Work order, it is the quantity.
Where-
work order page 35
No, you had taken me through it.
for the contract.
Anyway, work order is at that page.
Page 35.
All right.
Contract page 37.
The brief facts of the case is that the petitioner was awarded the aforesaid work for segregation of legacy waste of 3,61,000 MT as per the terms and conditions, specifications and timeline fixed in the RFP. Stop. By order dated 22/12/2020. It is page 35 or something, huh? The relevant, where is that conditions? Those conditions?
Page 37, you know, in
No, the instructions to bidders or page
my lord,
37.
say page 37. That's the contract. Page 37, the
So this work was given pursuant to your participation in this tender process, I think. So Pothamot to me Kuba, that the brief facts question, that bids were invited from bidders for bio mining stroke segregation of legacy waste by NIT dated. NIT dated
it's
page 21 it starts, but the date is not there.
is 2010-2020,
2010, so and so.
page 19.
Wherein the scope of work reads as under. Page 24, clause 3 to Pura Didiba. Thereafter, a petitioner was awarded so and so by that date. Pursuant to the aforesaid allotment of the work, an agreement was executed by the petitioner with the GMC authorities on 31/12/2020 for segregation of 3,61,000 MT as per tender terms and conditions. The scope of work as specified in the Annexure 1 of the said agreement reads as under. Page 39, scope of work to deliver. It appears that thereafter, the petitioner, after installing CCTV as per tender conditions and using the GMC weighbridge for weighing the legacy waste, started the work. Thereafter, several bills have been raised time to time, which having been verified, which allegedly having been verified, and which allegedly after being verified was paid to the petitioner. However, two bills dated
18/4/2022 and 18/5/2022.
two bills dated 18.
4/2022.
It's so unlegible, these copies.
18/4/2022.
Page 61, isn't
Page
it?
61.
18/4/2022 and 18/5/2022 for total that hai crore to, totaling so and so was despite verification of the same has not been released to the petitioner till date. Situated thus, the present writ petition has been filed. Correct? This is the brief facts.
Yes, my lord, may kindly refer page 64 and 65 also.
I will.
That's
This is only the initial facts.
Yes.
Mr. B. Kaushik, learned counsel for the petitioner, submits that despite the petitioner's bills having been petitioner's work having been verified by the executive engineer and the chief superintending engineer, the legitimate dues of the petitioner has been kept pending since 2022. He further submits that deprivation of the petitioner's legitimate pending bills is violation of his article of the obligation of the state respondents under Article 300 capital A. He further submits that
the petitioner is also a small enterprise, my lord, under the MSME Act.
that the petitioner being a small
Small enterprise,
enterpriser under the
MSME Act,
MSME Act
2006.
2006, non-clearance of the legitimate dues of the petitioner has totally prejudiced and detriment his interest. He accordingly submits that the petitioners have been arbitrarily treated by the state respondent. He further submits that despite the petitioner using the weighbridge of the respondent GMC, the so-called committee constituted by the respondent GMC to verify the two pending bills of the petitioner has, in a most mechanical and arbitrary manner, rejected his claims on the ground that the petitioner has not submitted the, what is that word?
The CCTV footage and the
No, the other one.
weighbridge slips.
That the weighbridge
Digital
slips. Electronic weighbridge slips. He further submits that the issue he further submits that it is the GMC who has to monitor the weighbridges after the petitioner either install or uses or hires the same from third parties. Stop. He accordingly he further, Mr. So-and-so further draws the attention of this court to the letter dated 12/6/2023 and enclosed as Annexure B to the affidavit in reply filed on such and such date to buttress the point before this court that the petitioner has also submitted all the requisite verification requisite documents before the respondent authorities so as to his claim could have been verified by the so-called constituted committee. However, the committee rejecting the same on the ground that the petitioner has not submitted the, what is that word? Please say it from there. Has not submitted the, no, the other word, the two words, no. One is electronic weighbridge bridge and pertain, no, other pertinent
documents
and other pertinent documents relating to the claim of the petitioner. Stop. Per contra, Mr. Bora submits that your affidavit was at page, that particular paragraph you showed, para 7.
76.
That was 7, na?
Page 76, para 8.
Yes, I got it. It submits that since the subject to invoice submitted by the petitioner did not have the signature of the executive engineer division 4 GMC, the same could not be processed initially. He further submits that the said officer was later on also arrested by the CM Vigilance in connection with allegation of misappropriation of public money. He further submits that a 10-member committee headed by the Additional Commissioner GMC as chairman was constituted by notification dated 23/8/2024 to examine the claim of the petitioner along with few others also, na? Or only petitioner?
Only petitioner.
Petitioner, huh? Stop. He further submits that the committee, having examined and having rejected the bills of the petitioner, no relief sought for in the instant writ petition, warrants to be allowed. Stop. Heard, peruse materials for diba. It appears that the two bills that it appears that out of the 11 bills submitted by the petitioner in connection with the aforesaid work, 9 bills has already been paid. It further appears that there is it is undisputed. It further appears that the aforesaid 9 bills were verified, and after verification, the bills was paid. The controversy arises out of the 2 remaining bills, i.e. 18/4/2022 and 18/5/2022 for so and so amount. It appears that as regards the bill dated 18/3/2022, the Executive Engineer GMC, Guwahati, on 19/4/2022 has issued the certificate of completion of satisfactory completion of the said work, which reads as under quote unquote page 63. It further appears that the inspector engineers, division GMC
Division 6.
Division 6, right? GMC on 7/6/22, further by letter dated 7/6/22 has certified satisfactory commendable performance and completion of the total work of 361,011.75 out of total order quantity 361,000.00 metric tons. Correct? Stop. It appears that the stand of the respondent for not releasing the aforesaid to bill amount is due to the absence of signature of the executive engineer for which a 10-member committee was constituted, which after verifying the claims of the petitioner on 7/9/2024, upon verifying, upon reviewing the claim of the petitioner, held that the petitioner failed to produce the electronic weight bridge slips or other pertinent documentary evidence to verify the work done. Stop. The minutes of the meeting held on 7/9/2024 reads as under page 86 A to A. Tiribapura. It is clear that the claim of the petitioner was rejected merely on two accounts. One, failure of the petitioner to produce the electronic weight bridge slips. Two, other pertinent documentary evidence to verify the work done. As regards the electronic weight bridge slips, apt to return back to the scope of work under the contract. Under the scope of work as extracted above, which has been specified also as annexure 1 to the contract agreement in question, the obligation of the contractor stroke bidder is to install a computerized weigh bridge with CCTV facility in suitable location for weighing of incoming legacy waste, and alternatively the bidder, the contractor stroke petitioner shall also have to arrange third-party weigh bridge for measurement of waste. It further appears that thereafter it is the GMC who shall monitor such weigh bridge under the scope of work clause. In the present case, it appears that the petitioner by letter dated 10/2/2021 has intimated the Commissioner GMC as regards installation of CCTV in terms of the tender condition. Letter dated so and so reads as under page 41. It further appears that by letter dated 10/2/2021, the petitioner has also informed the Commissioner GMC as regards using of the weigh bridge and hiring and using one of the GMC weigh bridge after repairing the same at his own cost. Since it is for the respondent GMC to monitor the weigh bridge, this court is finding difficulty to accept the aforesaid ground, to accept the reasoning of the said 10-member committee rejecting the claim of the petitioner on the ground of failure of the petitioner to produce the electronic weight bridge slips. Stop. That apart, it appears that the petitioner has that are at this juncture, apt to refer to the relevant paragraphs of the affidavit in reply filed by the petitioner in response to the affidavit in opposition filed by the state government, by the state GMC, respondent GMC, which reads as under paragraph 7, page 90. Apt also to refer to the letter dated 12, this letter is dated 12/6/23. 12/6/23, enclosed as Annexure B to the said affidavit in reply, which reads as under page 96. A paragraph 7 to page 90, 90 paba, or 8 to 96. The pura diba. Reading of the aforesaid letter, it appears that the documents necessary for reviewing the findings and claim of the petitioner were available before the respondent GMC. However, there is no whisper to the same in the findings of the 10-member committee. On this, in view of the foregoing, this court is of the considered view that we considered view that the findings of the 10-member committee cannot, that the impugned rejection by the so-and-so appears to be contrary to the principles of natural justice. That being so, let the committee review accordingly. This court is of the view that this writ petition can be disposed of by directing the respondent GMC to re-verify, to review. I think I'll say the review, isn't it?
Put it before the committee that.
Not this committee. To reconstitute. Okay, you can the same committee. It can the respondent GMC is directed to place the entire matter before the 10-member committee once again, and with the relevant documents, whereafter the committee shall consider all the documents vis-a-vis the final completion certificate issued by so-and-so on so-and-so against the petitioner's work afresh within a period of
2 months.
2 months from the date of receipt of the certified copy of the order. It is needless to be clarified that the petitioner shall, if required, be also afforded personal hearing, opportunity of hearing, so as to put forward his claim before the said committee.
Based on the recommendation of the committee, let the commissioner take a decision, because committee will recommend and they will sit upon it.
No, then after,
Regarding the payment,
it is needless to be clarified that in the event the committee recommends in favor of the petitioner, since it appears that the alleged non-release of the bills is pending since 2022, the commissioner, respondent number the respondent number so and so shall release
Two.
the amount in terms of the recommendation within a period of 1 month.
It will be 2 months.
No, that releasing part 1 month. 1 month from the date of receipt of such recommendation, if any.
Grateful, my lord.
I'll edit it, huh?
Yes,
So,
highly obliged.
yes.
Yes. I am for the respondent.
Yes, Mr. Saikya?
I am for the respondent, lordship, the petitioner.
Yes.
Lordship, my senior is busy in court number 5, Lordship, after some time, Lordship.
Busy.
Lordship, the case is otherwise ready for final disposal. So could it be after vacation?
All right, we'll have it after the vacation then. Heard Mr.
A. Hussain.
A. Hussain, Learned Counsel for the petitioner, also heard Mr. D. Saikya, Learned Advocate,
Senior counsel.
Learned Senior Counsel, assisted by Mr. B.D. Chaudhary, Learned Counsel appearing for the respondents, as prayed for, relist on such and such date. Give a date.
Lord, highly obliged.
22nd. Item 6.
I believe yours. In this case, we are directed to file an affidavit being on record the status report. Now, affidavit has been sent for voting, and some time is required, madam.
As Mr. Your name?
M. Setya,
M. Chetia, Learned Government Counsel submits that the affidavit has been sent for vetting and upon receipt of the same shall be placed, same shall be filed before this court. In view of the same, relist after 3 weeks on a date to be fixed by the
Lordship,
registry.
this matter is pertains to referring the investigation to CBI, Lordship.
So that affidavit has to come,
Lordship,
no?
kindly fix it that, Lordship, because from.
All right, after the vacation. Yes, next.
Item 7.
Is it your lordship? Your lordship may kindly take up the matter after some time, lordship.
What is this?
has been filed challenging the short tender notice also.
Tender notice.
Yes, lordship.
Pleadings are complete.
The lordship, they are enjoying the interim lordship.
Okay, then after vacation.
Lordship,
Mr. Your name?
no, your lordship may kindly consider, lordship, after some time, lordship. The learned senior counsel. lordship.
All right, we'll wait for some time.
Highly obliged.
Right.
Item 8.
Lordship, I am filing the affidavit today, Lordship.
The Mr. B. Chaudhary, Learned Standing Counsel Finance submits that the return shall be filed during the course of the day. Relist after 3 weeks on a date to be filed by the registry. In the meantime, if the petitioner, if so advised, shall file their rejoinder against the said return. So if after filing you want, you can file your.
This has been going on for the last.
It is needless to be clarified. No, this is the 25 matter. We'll see on the next date. Yes.
Date may be fixed, your lordship.
Next.
Item 9, 10.
Next. Don't worry, date will be given. Nowadays, if you have difficulty, you come. Yes.
May I please, your lordship? Herein the matter pertains to settlement of market, your lordship.
Segregate, huh? Settlement of market. Affidavits.
Hearing, I endure on behalf of respondent number 5, your lordship.
Yes.
We have filed a consent affidavit, but PNRD department has to file an affidavit.
Who is appearing for PNRD? Who is appearing for PNRD?
So they are.
Heard Mr.
A.M. Khan, your
M. Khan, Learned Counsel for the petitioner, also heard Mr.
R. Majumdar,
R. Majumdar, learned counsel appearing for
respondent number 5.
respondent number 5. You have filed your affidavit.
Yes, consent affidavit we have filed.
Huh? What affidavit?
We have filed a consent affidavit.
When did you file it? That affidavit is not on record.
Yes, it has been filed on 22nd.
Mr. So-and-so submits that an affidavit has been filed on
22/9.
22/9/2025.
Yes.
However, the same is not on record.
Okay.
None appears for the respondent PNRD.
Yes.
PNRD.
PNRD on call. It further appears that returns on behalf of the respondent PNRD is also not on record. Relist after 3 weeks on a date to be fixed by the registry. In the meantime, let registry verify the said affidavit and place the same on record. Are you for PNRD? Then don't say none appears, give her name. And how much time do you need?
After vacation.
I'm posting it after vacation. You
But
don't
this
have to
is
tell
inside-
this code when to post the matter. Kindly tell this code how much time you need to file your returns. Just don't bunch into the courtroom and say what your senior has told you. How much time you want? 3 weeks time. 3 weeks time. All right. Let the affidavit come. The affidavit is also not on record.
Fixing the matter.
It'll come after 3 weeks. Yes.
Supplementary list item number 17.
This is a 2018 matter. Where is the petitioner?
We have filed our affidavit, Lordship, wherefrom it reflects that it's a visual and Lordship they are occupying.
Petitioner is not there.
Lordship.
Petitioner is on legs at another court, and Lordship, she has informed me. Lordship, may kindly pass over the matter for a few minutes, sir.
All right.
She's on her way.
All right.
Item 18.
17, I need further 2 weeks time to file my.
Which one?
17 and 18 and 19.
18 and 19. You want 2 weeks time? But anyone from HRA Chaudhary's team? Petitioner? None appears for the petitioner on call. Mr. So-and-so, standing counsel? Learned counsel appearing for the
Statement.
state counsel.
Yes,
Learned state counsel within bracket respondent number 3-4 seeks 2 weeks time.
2 weeks time.
2 weeks time to file return in the matter. Relist after 2 weeks on a date to be fixed by the registry.
If we are newly implemented respondent.
You will file something?
Yes.
Mr. So-and-so, learned counsel appearing for the newly implemented respondent number
7 and 8.
7 and 8, all similarly seeks how much time?
2 weeks.
2 weeks time.
Hello, can it be 3 weeks?
All right, 3 weeks. Yes, next. Because 2 weeks will be consumed in the holiday. Yes.
Item 19.
18, 19.
Yes, call that hearing.
This is 10 big.
Timing.
10 big item number 1.
Matijwa.
I am praying for timing passport in Methodist. He is on legs, my senior.
As prayed for relist after 2 weeks on a date to be fixed by the registry. Yes, next.
10 big item number 7.
Yes, Mr. Das.
This is, now I find it is covered by a judgment passed by Justice Devashish Borua. I'll place the fact, my learned friend has made a list of dates. I say that will cover. The date, may I just point out? This will cover.
Give a copy of that judgment to the other side.
Copy. You have? Give it, give copy. Copy to him. Yeah, may give him.
Because if you're saying it's covered, must give a copy
Yes.
to the other side also so that they get a chance.
Nitin. Hello, what has happened? May I just go to the facts?
Yes.
She takes this one. This is relating to the destructure of vehicle gate.
This is relating to
Destructure of vehicle gate. settlement.
Yes, vehicle
It was-
gate.
Yes, it was settled in the, for the period 2024 to 12/24. Okay.
Yes,
At rupees 50 lakhs.
yes,
And my lord, on 23/12/24, it was settled at 1 crore for the year 25 without tendering.
yes,
This was challenged before this court, and the
yes,
High Court set aside the order of settlement
yes,
with a direction to settle as per law.
yes,
Similarly, my lord, Mandar Desa vehicle gate was settled without tender. This was also set aside by the court
yes,
and directed to settle as per provision of law,
yes,
as there was no NIT for settlement.
yes,
Now tender was issued, my lord. This is where the problem, the thing started, my lord. Page 27, 26, 325. Tender issued for settlement of both the gates, Mandar
yes,
Dasa gate and Ditokshara gate. This your lordship will get it at page 27.
yes,
May I take your lordship to page 27?
yes,
So Mandar Dasa, your lordship will kindly see the tender condition. And the
yes,
Mandar Dasa vehicle gate, it is for 75 lakhs 37,000. And Ditokshara vehicle gate is for 75 lakhs.
yes.
As per this tender, my lord, Mandar Desa vehicle gate has been settled at 5 crore some amount. And Ditokshara they have not settled. They have re-tendered it. So this your lordship will get it at tender has been opened. This at page 132.
Sorry, what did you say? Mandar Disa, they have
settled.
they have settled.
That and Ditokshara they
You
have not
don't have any problem with that. There's no dispute
settled because I have participated in Ditokshara
in Ditokshara. Now
And-
here, what has happened?
and they have re-tendered it.
Retendered.
Re-tendered.
Yes.
This, the earlier, my lord, when we filed the tender, your lordship will get it at tender opened and page 132. Your lordship will kindly see page 130. These are the relevant
Page
132.
132. Yes.
These are the comparative statements. These are given by the council for the NCLs. My lord, as many as 5 tenders have been found to be invalid. Tender amount not
Filled up.
etc.
Yes.
Petitioner stands at petitioner, my lord, he has quoted
His number, serial number?
10.
10.
1 crore 43 lakhs. But
Yes.
there are 3 above him.
Yes.
3 above him and 1 below him. The 3 others, they have not come before this court.
Yes.
And 5 are invalid. And the other person who is below him, they also did not come. I have made a statement in the.
They have settled with someone.
No, they have not settled.
They have not
Because
they went for a fresh tender.
they
You
went
are
for
challenging the decision of fresh tender.
fresh tender and for cancellation.
So above you there are 1,
2, 3.
1 number of serial 1, serial number 2, correct?
Yes.
And serial number 3. Serial number 5 is also there.
Serial number 5 is also there.
So 1,
Serial
2,
number-
3, 4.
Serial number 3 is below me.
Serial number 3. You mean to say the okay. Okay.
Because I quoted one line
Higher.
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 So these people, they are not interested. This is what I have said, but I'm not on that.
All right.
I'm
Because
saying
you've not
whoever
made
gets
them
it.
parties also.
Because whoever gets it, Malad, their re-tendering process is wrong.
Correct.
So what I have stated, Malad, what they say, my lord, in their affidavit in opposition,
Yes.
order of cancellation, your lordship will get it at page 46. This is your cancellation. We did not get it, but they say why we have issued this order. I accept it. I'm not going to.
Yes.
My lord, may I read this one? Page 46.
Mr. Counsel, I am taking it up thinking we can make an attempt to dispose it of today. Yes.
Thereby informed that the tender for the right of collection of entry tax of vehicle, detective vehicle gate was called, white notice dated so and so, and was opened on so and so. They have opened it. Your lordship can be noted. After opening.
One second, 1 second. Gate was called on dated so and so and was opened on so and so. Yes.
So on that comparative statement, your lordship has seen.
Has
that
been prepared and
it-
submitted.
the
Yes.
comparative statement has been prepared and submitted to the council authority for acceptance and approval of the rate of the highest bidder. The said file has been returned back from the council authority with a direction to cancel the tender process and to call re-tender by increasing the tender value from 75 lakhs to 1 crore. Stating that the tender value is too minimal, accordingly, the tender process of Vitapsara vehicle gate is hereby cancelled and re-tender process will be initiated. Now your lordship will get to see the next page, 47. This is dated 19th April 25, cancellation order. And the next page is 24th April 25. This is the resolution taken by the council.
Mm. 47.
Yes. This is dated 24th April. But prior to that, my lord, they have done this.
No, what are you showing from 47?
47, my lord, because the cancellation order is as per, my lord, has been returned back from the council authority with a direction to cancel the tender process and to call.
Where are you reading that?
That is at page 47, that's the
Yes.
cancellation order.
The house discussed.
Yes, and now this is the.
1 second, I'm just missing something here. The house discussed the matter regarding a tender. Is merely less and would be a great loss for so and so. So they are saying it's less. Hence it is approved to issue a short tender notice inviting a re-tendering. Yes.
So now, the viability range was, what I'm saying, viability range was never mentioned in the NIT. So on the ground that the whatever amount they got it is now they're saying 1 crore, earlier it was 75 lakhs. And the petitioner has quoted 1 crore 43 lakhs. Can this be a reason for cancellation and reissue of a tender? This is the only question that we can do. So lordship will kindly see, so yesterday that judgment passed by the Honorable Justice Devashish Burwa.
And this 19th April is you mean to say this came after?
After, yes.
24th
Yes.
April.
And the tender committee, they have to accept it, madam. Why they send it to the council? And one gate has already been settled.
This is strange. How did the cancellation
That is-
order?
So I got a state point, madam, state judgment in the absence of the vibe, because in this case where the Honorable Justice Devashish Burwa decided, where the L1 was rejected.
Why are you referring to the names of the coordinate bench? Yes.
Sorry, madam, it's a single judge. Yeah,
Coordinate bench judgment of
yes.
this court. Yes.
that was an L1 bidder was rejected on the ground that he will not be able to conclude the contract because his rate is too low. The court said, madam, in the absence of any viability range mentioned in the tender condition, you cannot do that.
That, of course, I'll have to apply my mind because one thing you see, ultimately they are the tendering authority.
Yes.
They are the best to know
Yes.
what is that they need for public interest. They may, unless of course the reasoning is so shockingly unreasonable, then of course this court will come. It is only that process, the decision making process. That is keeping all that for a moment. What you have demonstrated from there, it appears that the decision of cancellation was before the minutes. So on what, ultimately this court will have to see on what basis the cancellation was done, correct? Because it is also tendering involves public money as well, because it's not and it's not a case that there was less participant. five valid tenders
More than the.
was there.
Ma'am, more than the
Who
amount.
quoted more than the amount, and out of which you are at serial number 4.
I'm at serial number. Well, I'm not saying that you give it to me, but tender.
So
cancellation
so
of-
now they have to come up
Yeah.
with their reasoning. How the because this court will only examine the decision making process. Now where are the records, or where is your affidavit?
Our affidavit, Lord, sir.
Where is your affidavit? What are you saying? How? Because you see, this court is not going to accept this page 47. 24 April 25 is an extract copy of the minutes of the executive committee held on 24/4/2025. This decision is after the decision of the executive committee on 19/4/25.
No, that is the tendering authority.
Tendering authority. Who is the tendering authority? The page 46.
Yes.
So page 46, tendering authority has already taken a decision to cancel. It says the comparative statement has been prepared and submitted to the council authority for acceptance and approval of the rate of the highest bidder. The said file has been returned back from the council authority with a direction to cancel the tender process and to call retender by increasing the tender value from so and so to so and so, stating that the tender value is too minimal. Accordingly, the tender process of so and so is hereby cancelled. Now it says it has been returned from the council authority. Now you have to show on what basis the council returned it back to the tendering authority prior to 19th April 25. That you have to show.
Lordship, in this respect, I would like to Lordship may kindly peruse page number 133, Lordship. 133, Lordship. This is the comparative statement, Lordship.
Yes.
In the comparative statement, there has been an opinion has been made, Lordship. So
Yes.
that cancellation order has been issued on the basis of the opinion being placed in the comparative statement, Lordship.
Where is that opinion?
Or 133, Lordship.
Yes. Although 10 numbers.
Or Lordship, the below one, Lordship, the official rep, Lordship. After opening of the tender, Lordship, it has been sent to the head of the executive committee, and the committee has put an opinion, Lordship. The official, may I read, Lordship?
Yes.
The official rate of Tokchara vehicle gate is 75 lakhs, which is very minimal of 1 crore, for which tender process should be done immediately by cancelling the tender, Lordship. On the basis of this opinion, that cancellation order has been issued, Lordship.
Yes.
Lordship. And after that, Lordship, after making that cancellation order, why the subsequent that executive committee has been constituted or has been set, Lordship, to decide, as because it has been pointed out that for the purpose of increasing the revenue purpose. So that's why that has been referred to the executive committee, and the executive committee has said, and that decision has been taken for issuing the short tender notice, Lordship.
That is for retender.
Retender, Lordship. So there is no malafide, Lordship,
Okay.
and no arbitrariness, Lordship. So, Lordship, in my humble submission, the tender has been cancelled after issuing the cancellation order, and that has been put in notice board. And in the writ petition, the petitioner has made a statement that there was no cancellation order, and they have prayed before this honorable court that as there was no cancellation order, so that short tender notice should be cancelled, Lordship. So, in my humble submission, Lordship, there was a cancellation order on the basis of the opinion being placed in the comparative statement and the sitting of the executive committee, and only for the purpose for getting the higher revenue, Lordship. In this respect, I would also like to submit one judgment passed by the court bench of this honorable court, Lordship, where it has been clearly stated for the purpose of the higher revenue, the authority can do.
Yes.
Lordship.
Give me.
And the citation that is placed by the London Senior Council.
That of course I have not seen, so I am waiting to see that during the reply.
Lordship.
Yes.
So in this respect, I'd like to submit, Lordship, where passed by this court bench of this honorable court, there was a judgment stating that there was a comparison between 4 to 5 relating to IMFL retailership, wherein the cancellation order has been issued as they have got the higher amount from the other tenders, comparing to the same IMFL, so 4 or 5 IMFL lordship. In that place, as they have got the higher revenue, they have expected higher revenue from the other district. So that's why it was cancelled. And that citation I can place lordship. Our only purpose of issuing this short tender notice is only for the higher revenue.
The decision which you wanted to rely is the 2024
2024 lordship.
Hanuman Fukan.
Lordship.
Hanumani Fukan.
Lordship.
Yes.
Lordship, relevant. Paragraph 19, page 5, lordship. There you go. Nice.
Yes.
Lordship, may I read?
Yes, please.
On considering the fact that the decision of the state respondents to retender the IMFL retail of license has been made only with the object for the government to earn higher revenue, lordship, keeping in view the fact that the bids submitted for the other location were much higher, this court is of the view that the said decision made by the responsible authorities cannot be said to be arbitrary or unreasonable. The government being the protector, guardian of the government revenue finance, the reasons for retendering due to a low bid amount of the petitioner when compared with the bids given for other location shows that the government decisions not to accept the petitioner's bid is not in conflict with rules so and so. The opinion of the government to go for a retender is not for any extraneous reason, but with the object of earning more revenue for the state, which is in public interest, lordship.
Yes.
So, lordship, in some case, this tender has been issued for settling of the two gates. One is, this is the in some cases for detector vehicle gate and the other for mandatory vehicle gate. In the mandatory vehicle gate, the authority has got the higher revenue. So, lordship, expecting the higher revenue because what happens, lordship, the vehicle which enters from that mandatory vehicle gate, that is for other tender, the vehicle which enters from that road, it comes back from the other in the case that detector gate, it enters from the same gate. So the revenue which they get from the mandatory gate, they're going to get the same tax from on the other gate, lordship. So expecting that higher revenue only, this short tender has been issued, and there was no malafide only for the purpose of higher revenue, lordship. This short tender has been issued, lordship.
Okay.
There is for 5 crores, it is settled in the Manatisa gate. So we are for expecting that more revenue than 1 crore, but this tender has been issued, lordship.
Okay. Yes.
Now, judgment you will also kindly say court in the bench.
That judgment you have given?
Yes, yes.
Oh, with that
Taposh
note.
Lodhira.
Yes, yes.
Taposh
Taposh Lodhira.
Yes.
Relevant paragraphs, Mr. Das?
Not relevant is paragraph 27 and 28.
Yes, Mr. Das.
In
One sec. Let me
sorry.
turn to
Sorry.
paragraph 27. Being the second last day, I can imagine you all must be very busy. Yes, 27. Yes.
Of the above case discussions, it would be seen that the respondent authorities have decided to cancel the said online and offline process initiated on 14/11/24 merely on the ground that the lowest bidder had quoted a very low rate. Here high rate, without taking into consideration as to whether the said rates so quoted, the petitioner herein would be able to perform quality contractual work. The terms of the notice inviting tender as well as the invitations of the bids do not in any manner refer to any viability range. No records have also been produced that the respondent number 6 and 7 have taken any decision prior to the tender proceedings, thereby fixing any viability range. This court further observes that the respondent number 6 and 7, being the tendering authority, have the power to have discussions with the lowest bidder if they have any doubts as regard feasibility of providing quality construction works with the rates quoted by the lowest bidder. However, nothing was done. Instead of adopting such an approach, the respondent tendering authority have cancelled the tender and gone for a fresh tender. This, in the opinion of this court, is unfair, unreasonable, irrational, as well as suffers from perversity. Additionally, the right of legitimate expectations of the petitioner, being the lowest bidder, is taken away without any justifiable reason. So directions have been issued, paragraph 29.
Yes.
So another decision, your lordship will kindly see, that is a judge.
Just one sec before you go to the next decision. Yes, your name,
D1000 Lords.
Mr. Thousand, you were saying something about this judgment. You were distinguishing it. What was that you said about this judgment? Why is it not applicable in the instant case?
Lordship, the court bench judgment, Lordship.
Yes.
Lordship,
This Taposh Lord Roy's case, the case which has been just relied by the senior counsel.
Lordship, in our case, it's relating to the higher for the purpose of the higher revenue. The short tender notice has been issued, Lordship. And in reliance on that, I have placed a judgment of this court.
That is okay, but anyway, I thought you said something about this as well. Yes, Mr. Das, which is the next case?
Next case, your lordship will see the judgment. I have provided a copy of the judgment WPC 21.
No, I don't think that copy is here.
What's it?
Good.
In the record it is there.
Earlier?
Yes.
You had given earlier? Problem is, if you give it earlier, it's not there.
Copy, can you give it? I'll provide. Here, my lord, the court says, my lord,
Unless the matter remains partheard, then what happens? It stays. Otherwise, perhaps it goes back to the filing, and I don't know. Sometimes these judgments are not available.
My lord, I understand that. Your lordship may kindly see this. The note.
The note, yes.
There the court says, my lord, after opening of the tender and when the rates have become very public.
Which one? The second case?
First case, my lord.
2161.
2161.
Yes.
No good reason for issuing second tender, as the issuance of the second tender after opening of the first tender.
Okay.
First NIT violates petition.
See, that is
the court
that
said
is the principle, as I said.
As
Ultimately, the reasons has to be
has
seen.
to be.
It cannot be that
Your
it can
lordship
be
finds-
at the whims and caprice of
Yes.
the tendering authority. The tender cannot be cancelled
This is
because
because
they have to be fair and transparent, right?
lordship will kindly see
Now, one thing which is troubling the court here is that yes, it appears that there are reasons. Now, this court is not sitting in appeal against the reasons given by the tendering committee, correct? No, that committee.
Committee.
I'm not talking about the after committee. That comparative statement, there is an
Yes,
opinion.
yes.
There is an opinion, and that opinion is saying that they want more. The conscience is that we want more revenue. Now, tell me one thing, Mr. Das. Under the terms and condition of the present contract, is there any similar clause as that of the facts of Taposhi, Lord?
Oh,
There is no clause.
yeah, lordship will kindly
No,
see.
you have not. I think you have not understood the code. I am asking: is there a similar clause like Taposhi Lord's case where the state the tendering authorities can negotiate with the lowest tenderer for a? Is there some condition? Because there I found there is a.
Tender is one that has page 27.
Is there a clause? Because
Because it says tender must quote reasonable rate, page 27 and 28. Tenderer must quote reasonable rate against each market.
Page.
Page 27 and 28.
27 and 28.
28 is the condition. Clause 2 is the only condition.
Okay.
Well, they themselves have set the valuation at 75 lakhs. Now retendering, my lord.
Yes.
Now, your lordship will kindly see, my lord, my submission is only two folds. One is that the tender itself, they have quoted a valuation. Now, how can they say that if somebody quotes, my lord, more than double, almost double, my lord, how can they say it is lower? Just because they do not, first they try to give it to somebody without NIT. That facts your lordship will kindly see. Earlier, my lord, they have given the same vehicle gate at 50 lakhs. I have given in the note, my lord. And subsequently, they have given it to somebody without NIT at 1 crore. As your lordship noted, my lord, that in the list of dates I have given, my lord.
1 second. Now it is 1 crore.
Now they have increased to 1 crore.
1 crore.
But my rate is 1 crore 43 lakhs. And they are higher than me also. How do you retender it? Just because you do not like the face. Earlier you have retendered it, given it without NIT. And this court has to.
I think the records have to be given.
It is there. They were directed to be brought in there.
Records are available.
Sure.
So therefore, only consideration, maybe after opening of the tender, is it fair on their part to retender it again? And that also on a vexatious ground, ma'am.
Where? These are tender records. Where is the records? No, why the records are some loose papers? You see, I don't know. Is this how records are given to court nowadays? The records of the tendering committee, the records with the note files. Where are all that? There are no note files. This doesn't look like a record. These are some loose papers. What is the authenticity of these loose papers, Mr. Counsel? The word record has you have to understand. It must inspire the confidence of the court. You have the whole thing is about fairness and transparency. You can just open this. These are all some forms. These are not records.
As per the communication, those are the records available with the
The
authority.
records, where are the records where all these minutings have been done? Correct. Where are those records? You please produce it on the next date. Otherwise, you are inviting trouble. I'm telling you, this is not the way. Mr. Barwa? Mr. Barwa? Can these be taken as records? Sharma, sorry. He may not have understood. Please tell Mrs. Hausen.
Clearly, only after December 25.
Heard Mr. D. Das, Leonard Senior Counsel, assisted by J. Lothar, Leonard Counsel, appearing for the petitioner. Also heard Mr. D. Thousen, Leonard Standing Counsel, NC Hills. You're appearing for NC Hills. Stop. The grievance of the writ petitioner is the impugned cancellation of the impugned cancel. Where is that cancellation order page?
46.
Impugned
46.
order dated 19/4/2025, whereby the tender for the right for collection of entry tax of vehicles at Ditok Sara Vehicle Gate in relation to notice, tender notice dated 26/3/2025 was cancelled. Though the note in the comparative statement of tender enclosed as Annexure 3 to the affidavit in opposition. Is this the affidavit in opposition? Affidavit in opposition or reply? I think in your reply you have Annexure 3 is in your reply, I think, Mr. Das. In the reply, affidavit filed by the petitioner on 8/9/2025 indicates that the official rate of Ditokchara vehicle gate is 75 lakhs, which is very minimal of 1 crore, for which tender process should be done immediately by cancelling the tender. However, it appears very clear. Go to continue. Stop. It appears that the records pertaining to the aforesaid tendering process, including the reasons for the cancellation, is necessary for effective adjudication of this of the issues involved in the instant writ petition, inasmuch as this court in writ jurisdiction is not sitting in appeal against the decision of the tendering authorities in cancelling the subject tender, but is reviewing the decision-making process. Relist on such and such date to enable Mr. So-and-so, learned standing counsel so-and-so, to place the relevant records pertaining to the tender process in question, inclusive of the note sheets. Give this back. Give a date. And Mr. Das, you take this back. It might again get lost. So I'm returning this note for you. Mr. Thousand, no? And Mr. Lotha. Mr. Lotha, you keep this.
29th October, November, December.
Reopening on Didiak? I'm giving you immediately in the reopening. You have it, Mr. Thousand.
50.
Yes, next.
It will be part of because your lordship.
It will come difficult. The moment it's parted, it might get. You don't know whether this bench is available or not. So next, yes.
Milord, our item number 1.
I was badly stuck into it too.
It will be taken up at 2, Milord.
I think I've already passed the order.
Milord, since Milord, to accommodate my learned friend. Milord,
Anyway, it's already done down
Milord,
after
can
vacation.
it be taken
Yes,
up at 2, Milord?
not today. Yes,
Being item number 17.
Milord, tomorrow.
I already have passed the order, Mr. Fukan. Yes, next.
Most obliged.
Being item number 17.
May please, my lord. I am on behalf of petitioner, my lord. As per order, last order, my lord.
To item
Panchayat
number.
17, my lord.
1 second, just 1 second.
As per last order, my lord, Panchayat and Rural Development has given direction to file affidavit.
Yes.
But they have not served a copy of affidavit.
Have they filed? Have you, who is that? You have, they have not filed. How can they serve a copy to you, ma'am? They have to first file. Only when filed they will serve. How much time? 3 weeks. Your name?
R. Kolita, my lord.
Heard Ms. R. Kalita, learned counsel appearing for the petitioner. Stop. Also heard Mr. H. Sharma, learned additional senior government counsel for the state respondent, and MS N. Bardalloy, learned standing counsel revenue, and MS P. Thapa, learned counsel appearing for I find it very difficult, these proxy business on appearing on behalf of Mr. S. Datta, Leonard Standing Counsel, PNRD. MS so-and-so Thapa seeks 3 weeks time to file return in the matter. Prayer is allowed, relist after 3 weeks on a date to be fixed by the registry. All right, ma'am. You want a date?
Date, my
All
lord.
right, give a date. Yes, next.
27. Highly obliged.
So order item number 11.
Yes, Mr. Deka.
May it please the lordship. This
You have
IA
filed an IA.
has been filed by the respondent number 5, lordship.
Yes.
Here, lordship.
You are for the applicant in the IA.
Yes.
You have filed. You are the original respondent number 5.
Respondent 5.
And Mr. Barua, you are
I'm for
the
the respondent
original
of-
petitioner.
I'm the petitioner and the opposite party number 1 in the, my lord, IA.
Okay.
My lord, this IA was served upon me on 17/9/2025. And I would like to file my response to that, my lord.
That is all right, but lordship.
It's a stay vacation.
All right. Yes, Mr. Deka.
Yes. Lordship, thing is that the IA is filed for modification of order dated 4/4/25, lordship, passed in the writ petition.
For
Lordship,
modification of which order? Page
4/4/20 at page 28.
28. Yes.
Before that, lordship, these two orders I have annex of the annex
So just 1 second. This is the order of which you are seeking modification, right?
Yes, annex to page 28, lordship.
Okay, shall I read this first, or should you want me to go to the earlier orders first?
Earlier order.
Okay, okay. We'll go with your
At
flow.
page 24.
Page
Page 24.
24. Yes.
By this order, lordship, recording the facts of the case, ultimately, lordship, at page 27.
Yes.
Para 7, petitioner to take steps for service of notice upon respondent number 5 by so and so. Then 9. This court is of the view that matter requires further consideration as such till the next returnable date status quo as on today should be maintained.
Yes.
Status quo order pass. Then lordship, they are continuing. Petitioner is continuing. Then this order has been passed, lordship. Kindly see at page
29.
Yes, 29.
Yes.
Heard so and so, Mr. So and so learned standing counsel health department submit that the contract agreement entered with the petitioner on 3rd April 2023 was for a period of 2 years with effect from 23 to 23. In terms of the said contract agreement, the period of contract to the petitioner with regard to supply of dietary articles to inpatients of Nagaon Medical College and Hospital, Nagaon, expired on 22 to 25. And therefore, the petitioners have no right to continue with the supply of the dietary article to the inpatient in the said hospital beyond 23 to 25. This court has also perused the order dated 28/10/24, wherein the status quo order was passed after taking into consideration that the petitioner's agreement would only expire on 22 to 25. Today, there is no valid agreement with the petitioners for supply of the dietary article in the said hospital, inasmuch as the agreement dated 3/4/23 has expired on 22 to 25. In that view of the matter, status quo order passed on 28/10/24 is vacated. Now this portion affected.
You are aggrieved by this
This
vacating of that status quo order.
No. Later on.
Later on.
Later part. The authorities of the Nagaon Medical College and Hospital, Nagaon, are permitted to make alternative arrangement for supply of the dietary article to the inpatient in the said hospital. However, this court makes it clear that the respondent shall not finalize NIT dated it should be 8/11/23 till the next returnable date. Now, Lordship, while passing this order in my absence, the fact that pursuant to this NIT, Lordship,
You are who?
I'm the L1 bidder. Pursuant to this NIT, Lordship, mentioned in, it should be.
You are,
8/11.
were you a party? You are a party, otherwise in the writ.
In this petition, yes.
You are a party, but that time notice was issued.
Notice was issued.
So you by then you did not receive the notice.
Both this order has been passed.
Ex party against.
Now, Lordship, this NIT, pursuant to NIT, Lordship, this NIT dated 8/11/23, the petitioner, the respondent number 5, both to participate in this NIT. If your Lordship kindly see at this Annexure 6, Lordship, at page 38, in that NIT dated 8/11/23,
Yes.
at page 38, Lordship, this is the bid status technical evaluation.
Yes.
The Indira Enterprise 1 is the petitioner, Lordship,
Yes.
and he qualified. Then Messrs. Ranjit Borua,
Yes.
second.
Yes.
This is respondent number 5 qualified. and
Respondent number
5.
5. Yes.
Then the other one is there. So since he was disqualified.
Okay. You are respondent number 5.
I'm respondent number 5. That's serial number 2.
Yes.
The petitioner is at
You
serial
have
number 3.
qualified.
Both-
Yes.
both qualified.
This is technical bid.
Technical bid.
Yes.
Then next page, Lordship, financial evaluation. Next page.
Yes.
That Ranjit Borua, he was the L1. Respondent number
L1.
5 was L1. He quoted this, Lordship,
Yes.
approach or something. That Indira Enterprise, the petitioner, he was L2. Then, Lordship, after this evaluation, they did not issue the-
Finalize. Did not finalize because of this order.
No. Prior to that,
Yes.
they did not finalize, awarded the contract.
Yes.
So we that next document, Lordship,
Yes.
page 40,
Yes.
in 10/1/24, we have submitted a signed copy of the agreement
Yes.
and the please the fixed deposit, and we requested to issue the acceptance letter.
Yes.
These are the signed copy of the agreement and other documents.
So agreement was already signed.
No. We have to submit with
A
the
signed
stamp,
copy of the
signed copy
agreement.
of the agreement.
Only your signature.
Our side,
So which they have to then
Yes.
sign and then
then
final
final
acceptance.
acceptance. But here in this case, they did not issue the acceptance letter. So on our part, we have submitted all this, Lordship. Then
This was done on which date? 10,
10/1/24.
10/1/24.
24.
Yes.
Then, Lordship, nothing has happened. Then 49, page 49.
Who's appearing for the authorities? Mr. Bora.
Yes.
Yes.
Showing this, while passing the order dated 4/4, this
There was an impression that
test
there is
was
no
not placed.
that there was no one
Yes.
to provide these dietary
Yes. And those
articles,
tax,
right?
Lordship, yes.
I think this is what you're trying to
Yes.
hint.
Because,
Isn't
Lordship,
it?
this
There was
tax-
one something there. Today, there is no valid agreement with the
Yes.
petitioners for the supply of dietary articles in the said hospital, inasmuch as the agreement dated 3/4/23 has expired on 22/2/25. So, according to you, this already you had emerged out as the L1, the agreement you had given. Only thing they had not formally.
No, even they have formally signed the agreement also. Then this.
Where is that?
I'm coming. That is why serially I'm coming.
All right.
That
Page 40 and then
49, Lordship.
49.
Since they did not acted upon our this representation and all, we wrote to the director of medical.
Yes.
Representation we have submitted annexing all these documents.
Yes.
Even then they have not done anything. Then, Lordship, one letter is issued at page 57.
Yes.
57 Annexure 10, Lordship, Ranjit Borua,
Yes.
regarding diet supply, indoor impatient. Last line I'm reading this. Therefore, you are requested to explain as to how would you be able to maintain good quality and standard of diet for indoor patients, Naga Medical College, at the lower rate proposed by your company.
Yes.
So next page, Lordship, we have given the breakout.
Yes.
How we'll
Yes.
do it. Then Lordship, even then nothing has done, then we have
Filed a case.
filed a writ petition, Lordship.
In this, this IA is what, 3 to 3613 IA is filed where?
I said that writ petition.
That writ petition, yes.
In the writ petition, one IA was filed, but in the writ petition, since we have no grievance against the writ petitioner, he was not made a party.
Yes,
Then in IA, Lordship, this IA
yes.
filed by the petitioner on 18/9/24
Hmm.
at page 61, Lordship, kindly see.
Yes.
Second paragraph, Lordship.
Provided that the parties
Mr.
may
Bora has
seek
obtained
opposition.
instruction to the effect that the authorities are interested in having a negotiation with the successful bidder so far relating to the price, inasmuch as according to authorities, the price quoted by the petitioner may result in supply of the poor quality of dietary articles. Then submit by the petitioner. Then Mr. Bora on instruction further submit that petitioner may visit the office chamber of the respondent number 4 for such negotiation at 2 p.m. on 29/24. In view of the aforesaid, this court restrains from passing any further order and accordingly provided that the parties may sit over the matter as proposed at 2 p.m. on 29/24 and settle the issue.
Yes.
Accordingly, Lordship, next annexer, we have personally appeared on the date fixed.
Yes.
Then, Lordship, at page 64, annexer 14, this pursuant to this court's order, Lordship, this letter has been issued on 29/24. With reference to the Honorable Guwahati High Court Height order in so and so, a negotiation was held today on 29/24 at 2 p.m. between the respondent number 4, Principal cum Chief Superintendent, Nagaon Medical College, Nagaon, and L1 tenderer, Messrs. Ranjit Borua, proprietor of Ranjit Borua, is in the office of the Principal cum Chief so and so. Both the parties agreed to the following: that Messrs. Ranjit Borua was L1 tender for supplying diet to in-house patients of Nagaon Medical College. Mr. Ranjit Borua has convinced that he would be able to provide food at the price quoted by him without any compromise to the quality of the food as accepted by the local authorities. 3, that as the original tender was opened on 29/11/23 and already 10 months have elapsed, and Messrs. Ranjit Borua has already submitted bank guarantee in January 24 for the aforesaid work. Hence, a guidance is solicited regarding the starting of the tenure of the contract and extension of the original bank guarantee as required. In view of above, it is decided that Mr. Ranjit Borua is to be awarded work order for supplying diet for patients for 1 year with effect from a date decided once the guidance as mentioned in point number 3 above is cleared. Now, next document, Lordship.
Yes.
By this letter, Lordship,
Submission of bank
submission
guarantee.
and bank guarantee,
Yes.
fixing the date.
An agreement copy.
Yes. Then, Lordship, this is the letter of acceptance. They issued the work order.
When was this?
Annexer 16,
21,
page 66.
21, 10,
21/10/24.
21, 10,
10/24. So Ranjit Borua work order in relation so and so dated so and so and being L1 bidder for the started tender and subsequent order of the so and so dated so and so, you are requested to start the dietary service for the patients of Nagaon Medical College from 1st November 24. You are requested to submit the signed contract in stamp paper for the same along with security deposit.
Yes.
So pursuant to this LOL, Lordship,
Yes.
next document we have submitted the signed copy and the security deposit, Lordship. And if you, Lordship, see the signed agreement,
Yes.
that is in page 64. They provided this copy to us.
All right.
They signed.
And sign agreement, and what are, you have, by this, you have also given
Security deposit.
Security
Deposit.
deposit.
5 lakhs rupees.
now that order. So, and this was done when? On 23/10/24.
24.
Now, coming back to that, let's turn back to that order.
LOL.
Page, no, that order of page 29, was it? Page 29? Yes, page 29. The order of vacation of which you are seeking vacation.
4/4/25.
Yeah, page 30. Today, there is no valid agreement with the petitioners for the supply of dietary articles. And this is what date? 4/4/25. But it was already there.
Yes.
This is what you're trying to show, right, Mr. Deka?
On this date,
It was already there.
NIT has already been settled.
Correct.
An agreement is executed. If your lordship see the agreement, it is dated 1st November 2024.
Agreement is dated?
1st November 24, and it is for 1 year. And page 70, lordship, this third column.
This is at page?
Page 68, Annexure 18.
68.
The signed copy of the agreement.
Yes.
And page 70, lordship,
Yes.
the NIT is mentioned. Then the acceptance letter that I have shown, that 21/10/24 letter of acceptance, it is also mentioned.
Yes.
Then,
Yes, Mr. Barma, you take your seat. Let us, yes, official respondents who are there. Yes.
only one point I may submit, lordship. Then, lordship, they have come up, lordship, with this writ petition saying that there is already a subsisting contract. Their contract, lordship, it was earlier to issuance of NIT, and that was not under tender process. Simply on the basis of an administrative order, that agreement was.
Mr. Deka, if this court turns the clock back to the status quo issued on the first date, do you have any grievance? If the clock is turned back to the first date, because you are seeking modification of the second judicial order, correct?
Lordship.
Now, if we turn the clock back to the first order where a status quo was given,
Yes.
do you have any grievance?
Well,
I'm only asking you that question.
Only that 1 year period is there, lordship. My prayer is that let them, lordship, because this is already settled due to this status quo order. It was stepped, and since they have not placed all these things on the date 4th of this thing, that is why, lordship, not to settle the NIT. But NIT has already been settled.
Correct. That is why I'm saying I'll turn the clock back to the original first day order where it was directed status quo.
Yes.
So whatever is there will follow.
Yes. Only
because it appears unless Mr. Bora has to show something more than the record to indicate that on that date there was no agreement, because it appears, Mr. Bora, that perhaps you may not have been briefed on that date by the department concerned, because looks like these agreements were there. If these were given to you, you wouldn't definitely wouldn't have made that submission. This court has that much confidence and faith when the learned counsel is appearing before this court. Correct? So I don't think at this stage you are disputing these documents, which is specifically the document, the work order 21/10/24, the submission of the signed agreements 28/10/24, and the document at page 68, the 1/11/24. Right? Now, if these documents are there, then your submission on 23/2/2025 at page 30 appears to be not correct. Right, Mr. Bora? Because your specific submission on that date was that today there is no valid this, of course, after your submission it was said, isn't it? So and so submits that the contract agreement entered with the petitioner number 1 as per so and so, and therefore the petitioner have no right. This court also has perused the order dated so and so, wherein the status quo order was passed after taking into consideration that the petitioner's agreement would only expire on 22/2/25. Today, there is no valid agreement with the petitioners for the supply of dietary articles in the said hospital, inasmuch as the agreement dated 3rd April 23 has expired on 22/2/2025. In that view of the matter, the status quo order passed on so and so is vacated.
Yes.
So we'll restore the status quo. We'll say that let status quo be maintained.
Status quo was regarding, my lord, running of the dietary article supply to the hospital.
By
the petitioner.
But right now it seems that you have already entered into an agreement. The petitioner's term expires on 22nd February 25. Isn't it? When does the petitioner's agreement expires? It expired on 22/2/25.
Yes, ma'am.
Right? Now thereafter you have already entered into a work order because the later part in this order says the authorities of the Nagaon Medical College are permitted to make alternative arrangements for supply of dietary articles to the inpatient. However, this court makes it clear that the respondent shall not finalize the NIT dated 18/11/23 till the next returnable date. But the fact remains that on that particular date, the NIT was already finalized. So in that view of the matter, I shall now vacate this order. And maybe that's all, nothing else is required. I'll vacate this order because it appears this is actually not correct. One sec, Mr. Dekar. It appears it's actually not correct. The entire basis of this order appears to be not correct. So I'll vacate the order. I'll allow the interlocutory application. You go ahead. You know what is to be done. It is not a case before you that there is no agreement with anyone at this moment. You've already finalized the NIT. There is no stay. Therefore, the public interest will also not suffer.
But now regarding the present position, whether, my lord, because I'm not sure today morning also I tried to contact, but I'm not sure whether what is the position now regarding the NIT or
Page 70. Page 70. Page 70.
yes, my lord, this is the agreement.
Yes. That is the present position. So the factually, that part is not correct. It is not that the NIT has not. Now, if the NIT was finalized prior to passing of the last order, then where is the question of you not finalizing it? You've already finalized it. So that is not correct. I'm going to make that correction because this is the document.
This part your lordship may interpret.
So that's what.
Yes, my lord.
Yes, if Mr. Borwa only to that part.
As a writ petitioner, I'm entitled to my say. And as an opposite party,
Yes.
your lordship would like to hear me.
See, on this part,
On this part,
I am only saying
may I just
because
place
it
what is
appears.
May I just place my side of the
Yes,
story?
yes.
Your lordship has already heard the other side.
Yes,
If
yes.
your lordship allows me, I'll
Yes,
place my side of the story.
Yes.
So, my lord, first thing, why have I come before your lordship?
Yes.
Why have I come? What was my grievance? Why did I come? Why did I approach your lordship? Because I had a subsisting agreement.
Mr. Borwa, I'm just letting you know that I am not saying anything further.
Yes.
I am only vacating this order.
So,
Because right now this interlocutory application is only for vacating the second order. I am not making any comments on anything. Now, both parties are at liberty to do whatever they wish to.
kindly,
So, so therefore, I'm saying confine your arguments to the first order, the second order.
so may
First order, that's status quo. I am
And
not saying anything.
that is already modified by the second order.
So, but the second order will go away now.
So therefore,
So if I set aside the second order, then the time goes back to the first order. That will remain.
so your lordship
You got that order.
So may I, if I'm
Yes.
if
I'm just giving you so that
I'm-
you make your submission now in that way.
if I'm reading your lordship's mind correctly, your lordship is proposing to put status quo order as on date. Is that what your lordship is proposing?
Correct. In other words.
In that case, my lord, I have no objection.
So that's what I'm doing.
So
because you see that first order.
What is the present
You see,
status?
Mr. Barua, the first order they have not challenged.
Okay.
They have not filed this IA for vacating the first order. Therefore, I cannot do anything. That's a judicial order.
Yes.
Day one vacation of the second order. Arguments have been made on that. It appears that the second order was primarily given on the basis of the fact that there was no finalization of the NIT, which appears to be factually incorrect because of the documents placed. I'm using the word appears. Prima facie. So in that view of the matter, I will set aside that order.
And your lordship will restore the status quo order.
I don't have to say anything. If
But
that
else will
order,
clarify.
you see, if that order goes away, the first order remains.
If your
That's all.
lordship clarifies that, then I have no other submission to make.
I
Because
am not doing anything more
if
than
your lordship is
that.
not doing anything, may I just place one?
Yes, yes.
Now, this is an IA which was filed.
You don't need clarification of judicial orders.
1 minute.
Yes,
Kindly.
yes.
Now, this IA was filed for on 17/9. Today is my lord 25/9. All I am praying is 1 week time to file my rejoinder. That's all I am praying.
Your 1 week time will
because my lord,
expire. You
am
see,
I not entitled to a reply?
the 1 week time is the problem with giving you the 1 week time is that this matter will automatically go away for 2 weeks. It appears that Mr. Barua, it appears that factually this order is wrong.
My lord,
And
am I not entitled to a reply?
Mr. Barua, you want, then you see, Mr. Barua, your reply is only what you can give reply on what is relevant from your point of view, right?
Exactly.
Now we are not on that. Can you say something about the finalization of the NIT? Are you privy to the government records?
I am not privy to the
Then-
government records, but may I place the factual position?
Tomorrow, you want your last chance is given to you till
I'll
tomorrow.
file my reply
You
tomorrow.
do want to do whatever, you have to do it by tomorrow. This court is taking up this matter tomorrow because it concerns the public interest as well.
No.
And it appears on record. Mr. Bora, can you have the records by tomorrow? As regards the finalization of the NIT, only on that part. You have that. Heard Mr. J. Dekal, Learned Counsel, appearing for the petitioner. Also heard Mr. A.K. Barwal, Learned Counsel, appearing for the original writ petitioner. Stroke respondent number.
My lord, I am writ petitioner, stroke respondent number, opposite party number 1.
Opposite party number 1, Mr. D. Bora, Learned Standing Counsel, held. Stop. By way of this the applicant is seeking vacation of the order dated 28/10/2024, passed by this court. No, this order is 4/4, right? Order dated 4/4/2025, passed by this court in WPC 5479 of 2024. Stop. Order dated 4/4/2025 reads as under, quote unquote, Corriba from 29 to 30. It appears that this court, upon the premise that the respondents has not finalized the subject NIT dated 18/11/2023 on that date, while vacating the status quo order dated 28/10/2024, permitted the authorities of the Nagaon medical respondent number, state health respondents, permitted the authorities of the Nagaon Medical College and Hospital, Nagaon, within bracket respondent number so and so, to make alternative arrangements for supply of dietary articles to the inpatients in the said hospital. It was further clarified that the respondent shall not finalize the subject NIG dated 18/11/2023 till the next returnable date. It appears from the interlocutory application filed that the subject NIT was already finalized on the date on which the said interim order on the date of on 4/4/2025, on 4/4/2025, on which date the said order was passed. It appears that on 21/10/2024, the principal cum chief superintendent, Nagaon Medical College and Hospital, Nagaon, issued the work order to the petitioner for starting dietary services for patients of Nagaon Medical College, Nagaon, Assam. Pursuant to the aforesaid work order, the petitioner submitted the required documents by letter dated 23/10/2024 before the Principal cum Chief Superintendent, Nagaon Medical College and Hospital, Nagaon, with duly signed original agreement in the appropriate format, and also deposited the requisite security deposit. It further appears that '68 now that agreement
Lot. 68 is there.
that pursuant to the aforesaid, an agreement was executed on 1/11/2024 between the Principal cum Chief Superintendent, Nagaon Medical College, Nagaon, Assam, with the petitioner. Which is that page you were referring at, page 70?
70 here, the NIT date is mentioned, NIT number and date. And the third paragraph, that letter of acceptance is mentioned, Lordship.
Third paragraph 3, the second party.
The first party, on accepting the bid of the second party, issued a letter of acceptance. Letter number so and so dated 21/10/24. In pursuance of the letter of acceptance, having entered into this agreement, and this agreement is for one year.
It does appears that the respondents, it does appears that a perusal of the aforesaid documents appears, a perusal of the aforesaid documents makes it abundantly clear that the respondent has already finalized the subject NIT dated 18/11/2023 with the applicant stroke respondent number 5 on 4/4 prior to the order dated 4/4/2025, prior to the passing of the order dated so and so. Mr. A.K. Barua, learned counsel, appearing for the respondent so and so stroke first that original petitioner demand stroke so and so, seeks an opportunity to file an file objection, seeks 1 week time to file objection to the interlocutory application. It appears that a copy of the interlocutory application was served upon Mr. Barua on
17/9/2025.
verify কৰি ল'ব, ইয়াতে থাকিব 17/9/2025. Stop. Be that as it is may, since and today is 25/9 so and so. Considering the urgency of the matter, this court grants 1 day time to so and so to file objection if so advised. Let Mr. Bora obtain specific instructions as regards the finalization of the NIT subject NIT dated 18/11/2023 and place the same positively by tomorrow. Relist tomorrow.
Only one thing, that in order that 4/4, there is a typographical mistake. The NIT is not 18.
Give me the date of the NIT. It should be 8/11.
Yes.
And
Earlier order it is reflected.
all right,
April 27.
8/11 बिली को बारे दिया.
Instead of 18/11/23,
Yes.
8/11/23.
You do whatever you want to do.
I'll file it overnight.
But you see, you have to understand that this is concerning the state. They have to, it is only for that. I am not
My
hearing the
instruction is,
repetition,
as
Mr.
on
Barua.
as on date, the food is supplied by a third party.
All right.
Neither by me nor by my
Next.
learned friend's client.
Next.
Obliged.
I will not interim to continue till tomorrow.
It's no interim.
Next.
Interim order passed earlier may continue till tomorrow.
All right, till tomorrow.
DPM.
Item 12, can it be after vacation, my lord?
Item number
12, my lord.
12. Mr. Chaudhary, I thought was here. All right. As prayed for, relist after
Vacation.
2 weeks on a date to be fixed by the registry.
So fix it, Lord.
All right, you ask, they'll give you. Yes, next.
For hearing. Item number 20.
That matter will not be
Yes, where is Soronia?
finished.
The problem is that I have already put a skeleton of the arguments. Now I'm not being able to proceed further.
She wanted to hear Mr. Sarania.
Yes, the last time also he had taken time. Then I'll release this matter. It doesn't look proper to be keeping it for pending so long as part heard. Mr. Chaudhary?
One more day, my.
One more.
Then appears for the petitioner on call, Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. R. Gohai, respondent number so and so to Sai Loba that ase nahoy. Yate thaki boi roba mo wait this.
And for respondent number 4.
M. Chaudhary is for respondent number 4 and Mr. B.D. Das, Learned Senior Counsel, assisted by J. Lothal, Learned Counsel, appearing for respondent number 5. Anyone else? Yes, M.S. Kemprai, Learned Standing Counsel, respondent number so and so. Anyone else? No. Okay. Give a date after vacation. Hello? Yes. 16th.
My lord, item 18 and 19, there is the interim meal.
Interim, if any. Okay.
18 and 19.
All right. Any more? Finished.